Hello everyone. So this video is going to be about freedom of expression in English law, particularly pursuant to Article 10 of the European Convention on Human Rights. Anyway, so it is a qualified right, not an absolute one. So some limitations on freedom of expression are permissible, but they have to be amply justified. And notice this convention right has indirect horizontal effect. So remember, privacy under Article 8 of the Convention and freedom of expression under Article 10, they sometimes collide, and courts have to decide which one takes priority in the particular circumstances. Anyway, so Article 10, what's the structure thereof? Well, Article 10, Section 1 says everyone has the right to freedom of expression. And it goes on. Article 10, Section 2 says the following: they must exercise these freedoms since it carries with it duties and responsibilities, may be subject to such restrictions. Then there's a diaresis, as are prescribed by law and are necessary in democratic society in the interests of diaresis. They're talking about legitimate aims. So it's specifically saying that whilst you have this right, it must be exercised responsibly, and the state is entitled to limit this right, but it's got to be a proportionate limitation. It's got to be in pursuit of a legitimate objective. It's got to be the sort of thing which is acceptable within a democratic society. We can't have a law to say you're not allowed to criticise the Conservative Party. That would be unacceptable. Or not say a law, you're not allowed to tell any jokes. Things like incitement to racial hatred or religious hatred, you can ban those so long as the definition from that doesn't go beyond what's acceptable in a democratic society. Okay, so this is a very significant piece of legislation. It is of constitutional import. As has been said by Lord Stein, freedom of speech is the lifeblood of democracy. That was in R and Secretary of State for the Home Department ex parte Sims, a case from 1999, because we could have these fair elections, we get independence of the courts, we could have a multi-party system, everything else in democracy, but if we don't have freedom of expression, it's not worth much, because we don't know what's going on. People can't express their opinions. We can't criticise elements of the state that are deficient or misbehaving. So let's see how broad expression is. So a handy side in the United Kingdom, this 1976 case, it said freedom should extend to material which offends, shocks and disturbs. Okay, so even highly contentious material is allowed under freedom of expression. This was because of the Little Red School Book. It was published by two provocative Danes, Hansen and Jensen, in 1969, and it was intended for teenagers, telling them how to beat the system, how to challenge grown-ups, and was really extraordinarily radical and anarchistic, telling them all sorts of things about sex and drugs and things like that. Could the government ban that or not? Because some people like Mary Whitehouse, leader of the the National Festival of Light, this sort of neo-Victorian woman, thought it was an absolute outrage. It was licentious. It was outraging public decency. Okay, so what is acceptable under Article 10, Section 1? Personal expression, saying what you believe, what you want, things like that. You're entitled to vocalize your opinions. You have the right to receive and to impart information, and indeed nostra. Okay, what are your ideas about politics or religion or really any other subject? So you can not only say it out loud, you can send it in a written format, you can send it by email, broadcast it over the airwaves, show pictures as well. Obviously, there are exceptions to that if it's something like child pornography. Okay, so what types of expression are there? Because freedom of speech, people often say that, it does not have to be literally speech. We do mean expression, even if we say free speech. It can be printed materials, things said out loud in public, things said on the radio, on television and so forth, podcasts. Everything applied to television, radio also applies to the internet these days and the print media. So the Pro-Life Alliance clashed with the BBC in 2003. Pro-Life Alliance is sort of anti-abortion, anti-euthanasia organisation. Is that acceptable or not? The Pro-Life Alliance, they wanted to show what abortion is really like, what these babies look like, the dead bodies of these babies who were aborted and things like that. The BBC didn't want to show this. So actions and behaviour, standing in the street protest, holding up a banner, That is a type of expression. Chanting things, wearing slogans in your t-shirt, badges. Percy against the Department for Public Prosecutions in 2002 was the case about that. Art, okay, so as in posters, paintings, drawings, also films. These are types of expression. This was in the case Müller and Switzerland in 1991, in which she was ridiculing the Blessed Virgin Mary, a figure of reverence for Christians the world over. Or there was Wingrove and the United Kingdom in 1997, another such case. There's no flag desecration law in the United Kingdom, incidentally. You can burn the British flag, or indeed any flag. Now, having said that, anything which causes other people fear, distress, or alarm is a crime. They don't specifically say that burning flags is banned, but you could say that intrudes on our freedom of expression too much. Think of that, all right? As a police officer told me, anything that causes others fear, distress, or alarm is a crime. Now, wow! If I shout too loud, that could distress some people. I say something people don't like, that would distress some people, wouldn't it? Burning a flag would distress some people, so that's unlawful. Anyway, so this is about the right to receive information, what could be sent to you in the post by email and so forth. There was Open Door Counselling Limited and Ireland in 1992. So the Republic of Ireland, not only was abortion prohibited unless there was a real threat to the life of the mother, but you weren't allowed to send or receive information about termination of pregnancy, unless it's sort of in a medical context, in a medical textbook. That was okay, but you couldn't say to women, this is how you can induce an abortion yourself, or here's the address of an abortion clinic in Amsterdam or something. No. And indeed, in the Republic of Ireland, if a doctor suspected that you were intending to travel abroad for the purpose of procuring a termination of pregnancy, he or she was obliged to inform on Gardaí. The Garda Síochána would arrest you to prevent you doing so. So this organisation had its case against the Irish Republic, and this organisation was seeking to furnish people with information about how to abort their children. So the law was changed after the X case in the Republic of Ireland, that whilst termination in the Irish Republic was generally prohibited, people were allowed to send and receive information about it. So the right to receive information, this also touches on public inquiries and holding public authorities to account. There was and Secretary of State for the Health Department ex parte Wagstaff to do with that killer doctor, Dr. Harold Shipman, serial killer from Lancashire in the 90s, who was bumping off these old deers, killed at least 20 of them before he topped himself, a sort of latter-day John Bodkin Adams. Wagstaff wanted to find out what actually happened. You can't hush it up. What were the failings in the system? My mother was killed. Okay, so restriction of this right. So prescriptions have to be prescribed by law. The law of the member state actually has to say, you can't do this. It can't be something really vague and open-ended. It's got to be necessary in a democratic society. The restriction can't be, well, you can't criticize people's clothes, or you can't say what you think about music or something. No, none of these things would be acceptable in a democratic society. The restrictions that governments place on freedom of expression must be pursuing a legitimate aim, as in making us a happier, safer, more harmonious society, maybe stopping people getting access to information about how to commit suicide, or buying illegal drugs or something like that, or promoting terrorism. Okay, so look on a bit more. Prescribed by law, in more depth. The Sunday Times test. This is Gillen and Quinton against the United Kingdom. So they have to see if there was a legal reason to interfere with our right to freedom of expression. And is it accessible? Is this restriction, is it something which is narrow enough? And is there clarity in the way it's written so we don't know what we're not actually allowed to say? So what are the permissible aims on the basis of which you can limit freedom of expression? Well, Article 10, Section 2 provides a very useful list. It could be because for national security. It could be to uphold the territorial unity of the country. It could be to promote public safety. It could be to stop disorder or crime. It could be to protect public health or public morality. It could be to prevent people's honour being attacked in the media. It could be to stop private information like your personal health records being published, or it could be to maintain authority and to uphold the independence of the judiciary. But go over these, and some of these are problematic. the one about upholding territorial integrity. Does that mean the Scottish National Party weren't allowed to put out their case? Or, Irish nationalists? Now, the UK government's never done that, never restricted that. But if you want to restrict things in order to promote national unity, that's what you do. And this is the kind of argument that Putin does. Oh, you can't divide the territory, you're an extremist organization. Anyone wants independence for any part of Russia is banned. I know this is not going as far as that. It simply would restrict their right to say what they want. Public morals, that could be anything. Republic of Ireland trying to prohibit people learning about abortion, that was to promote public morals, well, indeed, to save our citizens from being killed. So let's look at the part that's got to be necessary in a democratic society. So the thing that you do needs to deal with an urgent social need, and it has to be in proportion to the objective that you are trying to achieve. So remember I gave you the possible reasons why you would be allowed to limit free speech, but it's got to be something which would be acceptable in a democratic society. For example, the cause of Scots separatism, banning people promoting that would be unacceptable in a democratic society. So that wouldn't be a legitimate aim, or any restrictions you place couldn't be more than you really need to have. For example, if in the Republic of Ireland when we didn't allow people to find out how to get an abortion, if we then banned doctors from learning how they're done in a medical textbook in case they needed to perform an abortion on a woman who had an ectopic pregnancy, that wouldn't be okay. So those Smith and Grady against the United Kingdom, Handyside against the United Kingdom, these are the leading cases on this. So let's look back to things like national security issues. There was Spycatcher, there was Peter Wright, that guy who worked for MI5, as in the UK's counterintelligence organisation. Peter Wright, he was hacked off when he didn't get as much of a pension as he'd been hoping for. He retired in the early 80s. He moved to Australia. He published Spycatcher, an account of what he's doing. He published in Australia. The UK government was incensed, and they said they banned it in the United Kingdom. So the Observer and the Guardian took a case out against the United Kingdom in 1991. Now, the thing is, it was, by the way, sorry, they didn't ban it in the UK. They banned it in England and Wales. It didn't ban in Scotland. I'm not sure about Northern Ireland. And if you purchase a book in Scotland, you could legally transport it into England and sell it. Well, I'm not sure you could sell it. You could bring it into England and give it to other people. And Tony Benn, this Labour MP, read aloud from it at Speaker's Corner, said this is ludicrous. I don't think there's any law against reading out loud from the book. Eventually the publication was allowed, and the court said, well, it's clearly no longer a secret because tens of thousands of copies have been published. Is but the Streisand effect. The attempt to keep it secret only increased public curiosity in this said tome. Okay, there's terrorism. For example, Brind and Secretary of State for the Home Department, or indeed Brind in the United Kingdom. These are early 90s case about Gerard Adams, who was in the IRA, although he's lied about it 1,000 times, and he was president of Sinn Féin, which was the political face of the IRA, and they were killing people all over the shop, civilians as well as soldiers, in the Republic of Ireland, in the UK, elsewhere, dealing drugs, robbing banks, committing all manner of crime, kidnapping people, torturing people, promoting sectarian hatred and racist hatred. So his voice wasn't allowed to be heard on the BBC because he was an advocate of terrorism. But eventually he was the ban was lifted. His voices could be said by an actor. Why couldn't you hear his actual voice? Didn't prevent his message getting out. So maybe it was pointless. The law applied in the Republic of Ireland too. So look at terrorism as against journalism. There's R. Miranda and Secretary of State for the Home Department in 2016. This was about a Brazilian national in the UK. So there was this power to stop something being published, and it was proportionate. However, according to paragraph 2.1 Schedule 7, it was incompatible with Article 10 because it was connected to journalistic material. All right? So the power is not PBL, if you know what I mean. Okay. And also Schedule 7 of the Terrorism Act 2000 is about a restriction on what journalists can say. So you might remember what PBL is. Any of you remember what PBL is? Test yourself. So going back over the possible ways in which expression can be legitimately limited. You remember what that is? So that's prescribed by law. The law's actually got to say what the limitation is. Okay, so go on to other cases. You can limit freedom of expression if you're trying to stop disorder or indeed criminality. There was R. Laporte and Chief Constable of Gloucestershire, 2006, about a demonstration outside a US Air Force base, and certain information not to be disclosed because it would lead to more disorder. Otherwise, R. Galestegui and Westminster City Council, 2003, about a protest just outside Parliament and how that would lead to disorder or crime. So you can limit freedom of speech in order to protect public health or indeed morality. So remember the open door counselling case against the Irish Republic, or Handyside against the UK. Arguably, this publication that Handyside brought in from Denmark, the Little Red School Book, was promoting immoral behaviour, particularly amongst minors, or Müller versus Switzerland, because Switzerland had a law against grossly offending religious sensibilities. You could offend them slightly. We have to consider about the protection of rights in others. Attacks on their good name, bringing them into disrepute, causing grave offence. Like Lingens in Austria in 1986, was his reputation was someone's reputation being trashed, or was that unfairly, and you had the right to prevent that, or was Austria taking away Lingens' right to freedom of expression too much? Issues of morality and blasphemy. There's Wingrove in the United Kingdom, Lemon and the United Kingdom 1982, because Lemon published this poem in the Gay News, a newspaper, The Love That Dare Not Speak Its Name, as Lord Alfred Douglas said, as in homosexuality, about Jesus Christ nailed to the cross and seeing a Roman legionary and having a homosexual fantasy about him. And 1979 that was published, and that mortally offended many Christians. So Mary Whitehouse, this moral authoritarian, she said the police ought to do something about it. They were prosecuted. They're found guilty. The Gay News, and there was a fine of £500 for the person who published it. The last successful conviction for blasphemy in the United Kingdom. The blasphemy law only protected Christianity, not any other faith. Notably, Life of Brian came out that same year, but there was no prosecution because they made it clear Brian is someone whose life is in parallel to Jesus Christ. It's not Jesus Christ. They made that plain in the first scene. Okay. So Lemon felt his freedom of expression had been unduly limited, but the European Court of Human Rights decided that it had not. And now Otto Preminger Institute and Austria, 1994, is another case about ridiculing Christianity. Okay, so how about racist hatred? There was Jersild and Denmark, 1994, about an investigation into racist groups. Was his freedom of expression unduly restricted? Or Garaudy and France, 2003, Holocaust denial, because it's a crime in France, Germany, Austria, and several other countries to deny the Holocaust, and he felt that his right to say what he thought was being unduly limited. Well, he lost his case. Mbala and France, 2015. This is a comedy routine by Dieudonné, whoever it is, a French chap who's often doing this gesture, some sort of political salute, and some people felt that he was promoting anti-Semitism. Surek and Turkey, number 1, about incitement to violence. Okay, so this was possibly a freedom of expression limitation that was unwarranted. So we have to look at the integrity of the democratic process. Animal Defenders International against the United Kingdom, 2013, their attempt to stop experimentation on animals, and was their freedom of expression being limited too much. There was also Section 321.2 of the Communications Act 2003 about sometimes when political advertising is not allowed on television, only party political broadcasts for elections. Maybe that's wrong. Maybe you should be allowed to buy as much airtime as you want, as you are in the United States. So we also have to think about confidentiality and justice. Journalists are allowed to protect their sources. People, I tell you that this is a journalist in confidence, you promise to keep my identity secret. I'd be in big trouble if I let it out. I might be sacked. My people might turn against me. My life could be at risk. So journalists consider this a sacrosanct duty. Otherwise, people won't trust them and divulge information. And they rely on these confidential sources, deep throat kind of people. So there was X Limited and Morgan Grampian, or there was Goodwin and the United Kingdom, 1996. Financial Times and others against the United Kingdom, 2009, or Ashworth Security Hospital and MGN Limited, 2001. So sometimes the government or the police demanding you have to hand over your notes, tell us who these people are. Some journalists sometimes refuse to do so, even when that's contempt of court, have gone to jail, rather than reveal who their source was. There was a contempt of court case about this, Sunday Times, the United Kingdom, 1979. Okay, so that's enough for the moment. So please follow me on Instagram, Facebook, and Twitter. Look at my other YouTube channel, George from Ireland. Book online lessons with me in law, many other subjects: history, politics, religious studies, French, English literature, English as a foreign language, and so on. Choose me to translate for you from French, Spanish, Italian, Romanian, German, or Russian, particularly legal documents. I'll help you with theses and dissertations and so forth, and pick me as your tour guide in London. Toodaloo.